Hello, everyone. Today we'll be talking about labor organizations in the context of labor relations. Now, remember the concept of labor relations that pertains to uh, the right uh, of uh, workers and employers to have their respective rights regulated pertaining to the mechanisms provided for by law uh, as to how the terms and conditions of employment are to be negotiated, adjusted, and enforced, the relationship between employers and employees, and the interaction and processes on how these rights are to be exercised. Now, normally, these rights may only be effectively exercised if there are legitimate labor organizations that in the process uh, may be um, uh, organized. Now, that is how important labor organizations are. Now, these labor organizations, is it enough that an association of individuals come together uh, to be a labor organization? Now, being a labor organization is one, but being able to uh, be considered as a legitimate labor organization is a different matter at that. Now, while we say that the rights of workers to self-organize is a constitutional right, it is, however, um, subject to rules. It is not enough that a group of workers will come together, organize themselves as a labor organization. It is necessary that conditions have to be met in order to acquire a legitimate status or to become what we call as a legitimate labor organization. Now, a legitimate labor organization is one duly organized and recognized by law as a labor organization for purposes of uh, collective bargaining. Now, the law provides certain conditions by which these labor organizations may be organized. Now, I invite your attention to Title 4 of the Labor Code, which prescribes the manner by which labor organizations are to be organized. Now, in 2007, this set of rules was amended by RA 9481, and from then on, it remains as such. And to make it more pro workers or pro labor, it is not that difficult really to organize one. In fact, the requirements for registration are quite simple. You have to pay a registration fee of about 50 pesos. The names and addresses of the labor organization, the officers, the meetings of the organization, the list of workers who participate, the number of membership, which should at least be 20% of in a bargaining unit. No, if it's been existing for the longest time, then even the annual reports and annual meetings, the copy of the Constitution and bylaws, when it was ratified, the list of members who ratify it. So these are just the basic requirements. And once you register it before the Bureau of Labor Relations, and in some cases concurrently with the regional director of the Department of Labor and Employment regional office, then you can later on be issued a union registration certificate and may consider yourself as a legitimate labor organization. Now, reality is sometimes this may seemingly be easy for some, but reality is often it may be difficult for other enterprises or other small-scale industry workers to do this. So what happens in that case? So for example, those working in factories, no, where the workers hardly are able to finish schooling, may they be allowed to, how can they be able to exercise this right to self-organization? Now, this is when the other types of labor organizations may come into play. When we talk of labor organizations, by the way, it may either be a federation or even a national union, or it can be just a local union or independent union, or even a local chapter. Now, this is what we call as chartering and creation of a local chapter. What is this all about? Now, if a federation, what is a federation or a national union? This is an organization of several other chapters or union that is part of the federation, which should be at least 10, and which should at least be respectively the official bargaining representative of the respective enterprises. So if you're a federation, you have 10 members. Each of those members are bargaining agents of the respective industries. Then you can organize as a federation and even continue to grow more. Now, that's why sometimes you read, you may be familiar with the Trade Union of the Philippines, some other trade union and big federations of organizations. These are the ones, no, that may be organized. Seemingly, when you talk of labor, we look at it some as an organization that is supposed to be a bit struggling. But when it comes to these federations, you can find federations that have plenty of money. Why? Because the local chapters that they have remit to them the membership dues, no, that they also generate. They also take part of it because they have to survive also. So sometimes, I've encountered in my many years of practice federations, no, of some unions. The president is driving a very nice SUV. So sometimes it was rather surprising, but then again, it seems that because they have good collections, they generate money. So they are able to finance their federation. Now, how vital is this? Would this federation and national union be? Now, in chartering or issuing a local chapter, even if the workplace cannot organize themselves as an independent union, the federation can assist them by accrediting them as their local chapter. Now, once this is done, then that local chapter is now regarded seemingly as also a legitimate labor organization for purposes of collective bargaining. So pwede na silang maging collective bargaining representative provided that the set of workers will later on agree that they will be the chosen bargaining agent. So magkakaroon pa ng tinatawag na certification election, wherein the employees will choose whether they want to consider them as the bargaining representative or not. Now, if that happens, then if they are chosen as the bargaining agent, then that federation and local chapter can work hand in hand to arrive at a collective bargaining agreement with the employer. So that is advantageous to the workplace, especially if they do not have the technical know-how in organizing a labor union or an independent labor union. Now, be that as it may, take note that to be entitled to the privileges of a labor organization for purposes of collective bargaining, there are also some reportorial procedural requirements. Submission also of the names of the chapter, the charter certificate itself, the principal place of business, the constitution and bylaws. It may be the same as the federation or it may be different, but in which case both shall be submitted, and other supporting documents under oath, no, that would attest to the existence of that federation. Now, whether it's a local chapter or it's an independent union or even a federation or a national union, this is submitted to the DOLE through the BLR, or sometimes, as I said, the regional director, who will have to act on the application within a period of 30 days, whether to grant or not. And if there's a denial, you can appeal within a period of 10 days for the reconsideration of that registration. Now, of course, when it comes to federation that is applying for registration, there are additional requirements that must also be made. Now, take note, class, that the right to self-organize is a constitutional right, and it cannot be curtailed, much less interfered with by the employer. Now, when one applies for it, technically, employers should not interfere at all. Now, let me just share with you my my journey before becoming a lawyer who also practices labor. Now, when I was president of the Central Student Council of the University of Santo Tomas, I got to be appointed also as a vice president of the UST Cooperative. It used to be one of the biggest cooperatives, in the entire Philippines, and I guess even in Asia. And well, for a time, it was really a huge organization in UST because it practically manages all the canteens in UST. There are many employees now, or probably even those holding higher offices, who used to work as a busboy or a waiter in the UST Cooperative. So it's a big organization. And at one point, I was its vice president, and so much so that when I finished my pre-law degree, not exactly a pre-law, I was a mathematics major. My objective when taking up this course in college was really to teach math in the US. Then I fell in love with the law. So I decided to pursue law. later in life. But before taking up law, I was appointed as personal director of the UST Cooperative. Now, what is the relevance of my appointment as a personal director? Well, I used to implement human relations policy. I represented management at that time. And at that time, there was a growing animosity between and among the workers and the management at the time, because at the time the cooperative then was already downsizing, because it was not allowed anymore to to take over some of the facilities. Other concessionaires were invited, so there was competition anymore. If you know that front part of AB building, which is now a park in fronting the civil law and AB, that used to be the place where a building was set up. Before the library was there, there was this building, the co-op building that we call. And that is where I used to work as a personal manager. And as I said, since there was a growing animosity, the workers at the time organized a labor union. Now, little knowledge is very dangerous, but maybe one of the characteristics that I have had is that, I was a bit stubborn, and, without being a lawyer and without even being assisted by counsel, I just tried to research, and I came across a decision of the Supreme Court, the case of Davao Electric Cooperative, whereby the Supreme Court explained that members of a cooperative are also co-owners, because the cooperative is a different type of organization. It's not for profit, theoretically. The members are co-owners, and they function for their mutual benefit. Unlike corporations, where you work for the entity, in a cooperative, you work for yourselves technically. So much so that when the workers themselves, who are also members, organized a labor union, the Supreme Court held that that would not be legal at all. Why? Because once they organize as a once they organize themselves as a labor organization, the purpose of a legitimate labor organization is to bargain or collectively bargain. Now, as a co-owner, it is rather absurd to bargain against yourself. Because of this rationale, the Supreme Court declared that it cannot do so, and affirmed the cancellation of the union registration. Now, guided by this jurisprudential teachings, so I took the initiative of filing in behalf of the cooperative a petition to cancel union registration. Now, well, in hindsight, that was a bold move, because under the law, management or anybody else should not interfere when it comes to the right to self-organize. But then again, I thought at the time that I had legal grounds. Well, a bit risky, but just the same, I wasn't charged with unfair labor practice. Why? Because I merely raised legal and valid concerns that would later on also affect management. So, long and short, when I proceeded with it, I was upheld. In the end, the organization was, the registration was not allowed, no? Because they are themselves members of the cooperative. It was rather an interesting case, because there was another lawyer from the other party And I wasn't a lawyer. I was just a fresh graduate from college. No? But it was fun because that even later on was one of the reasons that motivated me to pursue law and to increase my appreciation towards labor law. I didn't fall for labor law because of that incident. Well, my love and devotion to labor law then was a product of me working at an early age of 17. So I was already working. I was doing odd jobs. And later on, when I started to read labor laws, I realized that, there has to be some protection for workers. No? So that's when I get to appreciate the course. And again, coupled with my pseudo lawyering moves, so I get to wonder maybe I will consider taking up law or proceeding to law school. Although me taking up law school was more of just a testing the waters scheme, so to speak. So I just wanted to know. I did not take up law then with the intention of finishing it. I just tried to enroll because I thought to myself that, well, maybe this is something good. So I'll just see. Over the years, I wasn't even, uh, expecting that I would finish. Some of my classmates were overly excited in taking up law. Some even consider their law school journey as the ultimate destination, that if they don't make it as a lawyer, they're dead. But for me, when they ask me, why did you take up law? Then I would tell them, I just want to know my rights. And before I know it, then I ended up finishing law school as a working student for a 5-year program. And then eventually I realized that, I have to take the bar exam just the same. And without me knowing, then I suddenly become an accidental lawyer. I found myself as an accidental lawyer. Never in my imagination did I ever conceive that I will become a lawyer. I just wanted to be a singer. No, kidding aside. So that wasn't really a plan. But again, these things, no, it motivated me. And successfully canceling the registration of a labor union on valid grounds was something that amused me at that time. And in a way, that was some sort of law practice, no, so to speak. Now, I am more mindful, however, that unless there are legal grounds to do so, you cannot just interfere in this right to self organize. Now, take note that apart from what was stated, no, this is a ground based on jurisprudential teaching. But if we will look at the law, the grounds to cancel a union registration is limited to 3 grounds: misrepresentation or false statement or fraud in connection with the adoption and ratification of the Constitution and bylaws, the minutes of the ratification and the list of members, or misrepresentation, false statements, or fraud in connection with the election of officers, minutes of the election of officers, and the list of voters. So these, and finally, the third ground would be the voluntary dissolution by the members. In other words, members themselves can decide to, okay, let's dissolve this organization. They can do that. Or the organization may find itself subject of these misrepresentations, in which case the registration may be nonetheless canceled. Now, under the principle of equity of the incumbent, if at the time of the creation of these rules, no, there are organizations that are already in place, legitimate ones, they shall continue to be as such during that time. Now, the next interesting question is what now? So after one is uh, organized as a legitimate labor organization, what happens next? Now, there are, as I said, no, early on, for every right comes great responsibility. So once you're a legitimate labor organization, the members or membership in that labor organization may also include rights as well as obligations. So the membership in a legitimate labor organization is subject to certain rights. Now, for example, the labor organization cannot charge you excessive fees uh, to be required as a member. So it cannot be excessive, arbitrary, or oppressive. So hindi pwede na, before you become a member, you have to pay 50,000 pesos membership due. That wouldn't be allowed. Now, as members, you may also actually demand all financial transaction records of the organization. You can ask that. No? That's also very important, no? Because there are some organizations which may also abuse the office. Now, take note that as members of the labor organization, they have now the right to elect the officers who are to serve for a period of 5 years. Now, the only requirement for you to run is you have to be a member in good standing. And whoever gets elected, no, there is an undertaking to submit the list to the dole, even those accountable officers, no, entrusted with the handling of funds, no, even appointed officers must be submitted. Now, if there are actions to be done by the entire membership, well, it has to be subject to due deliberation. Meaning, there has to be an undertaking to discuss it thoroughly, and it should be approved by the general membership through a secret ballot. No? Now, in some cases, the board can decide in their behalf, no, but only if there are compelling reasons, such as force majeure, no, and similar grounds. Now, eto, uso ngayon ng red tagging or membership in terrorist groups, which is not prohibited. Now, a labor union shall not admit those who are part of or who they shall be responsible if they knowingly admit those who are members of subversive organizations or have done similar deplorable acts. So, if you are part of a subversive organization and you engage in that activity, then that may be a ground to exclude you. Now, also those who are convicted no, by if you're convicted uh, for a crime involving in for a crime involving moral turpitude. What's a moral turpitude? Anything that is vile and wrong. No, I mean, if you're convicted of that, you can no longer be part of a labor union. But of course, the conviction presupposes a final conviction. Okay. Now, aside from those, um, the members or even the officers of the local of the union are cannot collect, no, um, uh, unless authorized by the constitution. In some cases, even the check ops and assessments from the salaries of the workers, they have to sign. There has to be proof that they agree to that effect. No? Now, if you pay for your membership dues under the law, you have to be given corresponding receipts for it. No? Or this should be maintained on the records. Now, if there are funds of the corporation, the rules provide that it should not be allotted to any other purpose unless expressly authorized by a written resolution adopted by the general membership. So ordinarily, it cannot be used for any other purpose. Why? Because labor union must be stable. So if you will deplete the funds in a labor organization, that would be concerning. That would be something that is um, uh, deplorable as well because it's not allowed by the rules. Now, um, if the union generates income or revenue, uh, they should be recorded also. That would establish its source. No, why? Because even the employer cannot just donate funds. No, um, now um, any action involving the funds of the organization shall prescribe after 3 years from the date of submission of the annual financial report to the dole. So if there are questions that one wishes to raise pertaining to that financial report, the person has a period of 3 years to question it. No? Now, this only applies to legitimate labor organization. And of course, if there is a failure with the periodic financial reports required by the law, um, um, it may be a ground to cancel the union registration. Now, how about the officers and members? Should they be paid corresponding fees to that effect? Well, under the law, they are not supposed to be given any compensation other than salaries or expenses if so provided for by the rules, or if if there's a written resolution authorized by the majority of the members allowing them to enjoy these privileges. Now, any election for that matter, any action on the part of the general membership must be made through secret balloting. And there should be no irregularity in the process. Otherwise, it can be a ground to impeach the responsible officers. Now, those who holds money in the organization or those who are responsible may additionally be required to render an accounting at least once a year within 30 days after the closure of the fiscal year, or as may be required. So this is important, of course, for purposes of monitoring. Now, as I was saying earlier, no special assessment can be made towards members unless they agree in writing. So yung mga attorneys' fees levied on labor organizations cannot be done. No? Now also, they cannot be made to pay for all activities of the union except those allowed. One of them is labor seminars and all. So yan, funds can be generated so that these are mandatory activities that should be financed. Now, any labor organization should also dutifully inform the members of this collective bargaining agreement, the whatever system, and all the rights and obligations existing under the labor code. Now, for this purpose, these organizations are encouraged to finance labor relations, seminars, and other labor education activities. Now, any violation of these rights and conditions shall be a ground to even cancel union registration, etc. And criminal and civil liabilities arising from violation of these provisions may also arise. No? So that is how serious it is to be a labor organization. So it is not an ordinary undertaking. No? Now, how about the labor organization itself? Is the labor organization itself also allowed to exercise certain rights? Now, under the same book, Title 4 in Chapter 3, there are rights of legitimate labor organizations. Now, these rights may not be enjoyed by ordinary labor organizations, but only by those legitimate labor organizations. Now, first off is the right to be the representative of the members of a bargaining unit. But this presupposes that they are duly chosen through the process of a certification election. It will be subject of a separate discussion, but when we talk of certification election, it is the process whereby majority of the members of the affected bargaining unit gets to choose a particular labor union to represent them. So once they do so, then the labor organization may now be the legitimate representative of these workers. No? So that would be one of its rights. Now, how important is that? Now, that's very important. Why? Because once this legitimate labor organization becomes officially a bargaining agent, then it can now request as a matter of right the annual audited financial statement of the enterprise even the balance sheet and the profit and loss statement within 30 calendar days from the date of receipt of the request. Um, um, uh, or even 60 days before the expiration of the uh, uh, existing CBA, or even during the collective bargaining negotiation. So this is a very interesting right, no? Well, right now there is a pandemic. Now, does this excuse enterprises to allow workers to negotiate now? Take note, class, that the constitutional provisions or the state policy in labor decrees that workers shall be entitled to their share in the fruits of production. So in other words, if the enterprise makes more money, then it is rightful that they share this profit to the workers. And this can only be done either voluntarily or even involuntarily if there is a legitimate labor organization. So what does this imply? Well, if the industry, despite the pandemic, if it can reasonably be inferred that it's making money, then this is a right that may be exercised by the labor organization or the legitimate labor organization. For example, the enterprises like big companies, no, like um, big companies like yung mga online services. They definitely make a lot of money in this pandemic. Now, how about schools? Now, there may be some schools that are really affected with the reduction of enrollment, but it is not exactly conclusive that it is not making money. Maybe it is not making more money, but it may still be making money. How? Well, if in the past you generate an enrollment of over 100 sections, and now you only have an enrollment of, let's say, even 50 sections, well, 50 sections will still be sizable. That would still be a big um, indication that it's earning, especially nowadays that practically when it comes to other related costs, workers now are the ones actually paying for it. No, the work from home scheme, even in education institutions, the students and the teachers are actually the one paying for it. The extra cost for the energy, and if facilities are no longer being used, they are just preserved, then somehow that could be also considered as big savings on the part of these educational institutions. In which case, notwithstanding the pandemic, it can reasonably be determined if at all management is making money, and you will see this only when you demand, no, for these financial documents, which may be or should be surrendered by the enterprise um, um, in favor of the labor organization as a matter of obligation. And of course, you will have to see. You'll see, no. In fact, it's quite easy to compare it in the past. If in the past management is paying operating cost for, let's say, 20 million as expense. Of course, in the following year, if there's hardly any maintenance fees, then the 10 million can disappear. So, I mean, these things you'll know if and when these financial documents are subject to scrutiny and are surrendered to the labor organization. And that is how important these labor organizations are. Now, um, take note of all these rights, no? But aside from this, a legitimate labor organization, being a juridical person, can also acquire properties. It can also sue and be sued in the process, no? So that's how, and it can uh, uh, own, as I said, properties for the benefit of its members. Now, um, what is quite important also for labor organization is that when it comes to any law, the income and the properties of legitimate labor organization, all grants, no, etc., are free of tax, duties, and assessments. So this is uh, a right, no, and may only be repealed if laws later on will be passed charging them taxes. No? Now, take note also that apart from these rights and obligations of labor organs, they are also to submit reportorial requirements, no? Such as the constitution, bylaws, etc. Annual financial report, because the labor organization is not exempt to likewise provide its own um, financial report. No? And list of members at least once a year or whenever required by the bureau. So they have to submit it every year to update. No? Um, and take note that if you do not comply with this, the officers may be held liable. Now, the next begging question is, who should be covered by this right to self-organize? Who can be covered in a legitimate labor organization? Suppose the entity is engaged not in profit. Is this covered? Now, Title 5 on the Labor Code provides that all persons engaged in commercial, industrial, and agricultural enterprises in religious, charitable, medical, or educational institution, whenever operating for profit or not, shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining agreement. Now, how about those who have no particular employers, like ambulant workers, yung itinerant workers, self-employed, rural workers, and all? Well, if they do not have particular workers, they can actually join a labor organization for their mutual aid and protection. So, pwedeng samahan ng mga pogi at magaganda. Yan, you can join them if, so to speak, wala ka namang trabaho. Mag-join ka na lang ng samahan nung mga ganyan. No? Kahit wala kang particular employer, pwede. So, now, the next question is, this is when we talk of the private enterprise. How about those employed in government? Or in the public sector? Siguro in the public sector would be a more appropriate terminology. Can they join labor organizations? Now, take note that it will depend. If the government-owned corporation has its own charter under the law, then it cannot. But if it is organized in accordance with the corporation code, but it is a government-owned and controlled corporation, even if it is a government-owned and controlled, they are subject to the provisions of the labor code. Now, why is this so? Well, a government or a state can exercise two functions under constitutional law. Both public and the other one would be proprietary function. or para siyang hindi siya for public service, so to speak, but para siyang mandate, para siyang individual engagement. Pwede yun. And it is usually done through this organizations um, of government workers. Now, government, not really government, but government sector. Yan. So, pwede sila. So, yung mga UCPB, yung mga in-acquire na assets ng government from the Marcoses, yan. If these entities are created under the corporation code, then for all intents and purposes, the workers that are subjected to the rights under this law and may self-organize. But those that are strictly in the government service, of course, for obvious reasons, since their salaries and wages are determined by law, the proper recourse to negotiate for better terms and conditions would not be through a legitimate bargaining organization, but through Congress. But they are not precluded to join labor organizations that would promote their general interest. No? But they cannot bargain. You cannot coerce the government to enter into a CBA because salaries and wages are determined by law, except those government-owned and controlled corporations that functions proprietary services or proprietary functions at that. No? The other question that needs answer also would be pertaining to managerial and supervisory employees. Now, are they eligible? Because by reason of their function. Now, I think, for example, one is hired as a manager. Ang title mo, floor manager. Are you now precluded to join the legitimate labor organization? Now, while it is true that as a rule, when you're a managerial employee, you are precluded from joining the employment of from joining the organization of the rank and file. Why? That's very basic because as part of management, I mean, your loyalty obviously is with the management. So you cannot, it would be clearly a conflict of interest under the circumstances. Now, the next question is, is it enough that since your title is that of a managerial employee, you are precluded? Now, take note, I invite your attention again to the legal definition of a managerial employee. And we've stated time and again that this may only be considered as such if it involves the discretion to exercise management prerogatives such as hiring, firing, transferring, etc. No, if these are clearly you have something to do with the business, no, you enjoy a certain rights in determining the management or how the business should be managed, then for all intents and purposes, you are a managerial employee. You cannot join. But the scenario I gave earlier pertaining to the adoption or appointment of a floor manager in charge of the first floor, who is supposed to be given the discretion to determine which side should he clean first. Is he a managerial employee? Well, obviously, he's not. So even if the title is that of a managerial employee, take note that it is not the title that controls the rights, no, of a worker, it's not the title. It is the nature of the function that basically is controlling. So you may be appointed as a managerial employee, but if you are not in essence a managerial employee, you can actually join the labor organization. How about supervisory employee? Well, in essence, the same principle. No, there has for you to be considered as a supervisory employee, you have to meet certain requirements, and among which would be the requirement that you should not spend more than 20 minutes of your time to routinary work, and that your recommendations are considered. Now, the law, nonetheless, still allows supervisory employees to organize their own legitimate labor organizations for the same purpose of collective bargaining. So even if you're a managerial employee, you can also negotiate for better terms, and you can organize a labor organization to that effect. Now, the labor organization of the supervisory employees must be different from the labor organization of the rank and file, but they can both be present in a particular bargaining unit or a particular enterprise. Now, implicitly, if both of them can coexist with each other, they both can also be part of the membership in a this in a federation or national union. So you can join forces. No? You can be part of this federation, although you're technically separate and distinct. Now, is it possible that one of the requirements to be part of the membership of a particular bargaining unit is the commonality of interest? So much so that if there are no commonality of interest, they should be separated. Other criteria includes prior historical practice, no? But in general, if you represent opposing interest, then you're exempt to separate the two. Now that can happen in an education institution for that matter. A school may have non-academic personnel and academic personnel. So the academic personnel should um, um, be separate from the rank and file. Now, but they can coexist in the same school, and both of them can also be part of a federation or national union. Now, how about a scenario where a member of a bargaining unit is transferred from one a set of workers to another? For example, academic staff, and then later on move to the non-academic staff. What is the effect? Well, the effect is that even if there's no resolution removing that member from the list, for all intents and purposes, the law provides that that worker is already deemed excluded. As a final note on this labor organization, take note of this motherhood provision, non-abridgment of right to self-organization, which provides that it shall be unlawful for any person to restrain, coerce, discriminate against, or unduly interfere with employees and workers in their exercise of the right to self-organization. Such rights shall include the right to form, join, or cease labor organizations for purposes of collective bargaining to represent of their own choosing and to protection subject to the provisions of the law. Now, so take note of that. No? The commission of an unfair labor practice, no, is not just a violation of a civil right. but it is also a criminal offense against the state. So one who is guilty of this abridgment of rights self-organize may be sanctioned criminally. But of course, there are requirements later on when we go to unfair labor practice. I will be explaining that more intently. Now, take note of those requirements, no, for better understanding. Now, take note also that subject to the exercise by the President or by the Secretary of Labor and Employment of the powers vested in them are under Article 260 or 264. The civil aspect of all cases involving ULP, which may include claims for actual, moral, exemplary, other forms of damages, attorneys' fees, etc., shall be under the jurisdiction of the labor arbiter. So if there is such coercion, you suffered, and all that, you filed with the labor arbiter for unfair labor practices. And the law provides that the labor arbiter must decide within 30 days. Okay. And even if you've recovered civil indemnity from the labor arbiter, you are not, we are not precluded from filing another case based on human relations on the civil code. So you potentially see so many potential indictment if you violate this. And apart from that, no, take note, however, that criminal prosecution will only proceed if there is a final determination of unfair labor practice. And take note also that if there is a determination of unfair labor practice in an administrative proceeding, that determination will suspend the running of the period of prescription. So, ganun yun. So, I hope this 1-hour lecture on labor organizations have enlightened some of you on this item. We'll be discussing more topics in the future, such as unfair labor practice and other labor-related laws and other non-labor-related laws. You can just comment any question, post your comments or any questions, and or send me a message, and I'll be responding accordingly. Thank you so much for listening, and have a good day.